the day. Judgment Day is what they've called it, and in a unanimous decision, they've upheld the declaration of William Ruto as president-elect. That is a 7-judge bench. And on the 4th issue out of the 9 in a unanimous decision, this is what we were talking about before we took a break. And the Supreme Court found that there is no evidence that the postponement of the election in Mombasa, Kakamega, Rongai, and 5 other areas across the country caused voter suppression. And Professor Sihanya wanted to conclude on this matter.
Yes, indeed. Yeah, there are these issues of contagion theory, rational choice theory, how voters behave in a general election. Actually, to add the main other points, in a general election vis-a-vis in a by-election. For example, the data from political science indicates that the turnout in by-elections, because now this became a by-election, 29th August, it was a by-election in Mombasa, and because it was not in the general election.
Okay.
And therefore, the data should not have been, they should not have used that data that look, the turnout was very low anyway. And there is also what constituency, because our general election turnouts are many times higher, and especially in areas of specific strongholds. Then there is the issue of the respective candidates, really. And then there is the issue of there was the question that Kakamega, you compare, Kakamega is better compared to Busia in terms of their voting patterns and numbers. And there was clear evidence that the turnout was lower in Kakamega because of the by-election rather than as compared to actually, the turnout in Kakamega was lower on the day of general election, partly because the gubernatorial was not being contested, if you compare to Busia, for instance. And if you also compare the fact that Kakamega is also a very important county in this. Kakamega is the 3rd largest county in terms of voters.
Okay. It's
only 3rd to Nairobi and Kiambu, and therefore those are numbers you don't take very, very lightly. So these are some of the, of course there may be a relationship with the MCA one, but you know, a presidential election is the main one we were focusing on. So the dynamics for MCA may be different, but you know, presidential is national, and presidential, there's issues of group behavior, contagion theory, etc., that really can raise the number. But there's a point that he had raised, which is just one, which is about the issue. He stated that 2017, he criticizes 2017 Raila because he thinks that it was a subjective view of the court. It was based on scrutiny, which came more or less like the second day, and which everybody said that this is the smoking gun. Smoking gun is a doctrine in criminal law. This was, and therefore it was also analyzed. So it's not that cannot just be called an issue of subjective.
Okay, Professor Ketch, respond to that.
So a few corrections, first of all, Ben. One, I read the petitions, I read the affidavits, I read the responses to the petitions, I read the affidavits, and I read the submissions of the of both parties. And I've come to some conclusion. I may be wrong, but they are my views nevertheless. Number two, on what I said about 2017 was that the test is subjective to the extent that it depends on the perception of judges. Substantial violation is really how the court sees it. In 2017, the court saw it the way it did. In 2022, the court has seen it differently.
All right.
That is what I was saying. And on this question of voter suppression, theories are hypotheses, and they have to be proved. And if you read the summary judgment, it will be very interesting to read the longer version of the judgment. But theories are hypotheses, they have to be proved. The court seems to be saying that you've presented very nice theories, but where is the evidence?
Okay.
And also, what was interesting to me was a demonstration by the IEBC that, look, why don't we take comparative counties, the turnouts in comparative counties, the turnouts in comparative constituencies, and see whether there has been a difference. As the IEBC demonstrated, there wasn't really much of a difference. Again, that may not be sufficient proof, but it just goes to show that it is always going to be very, very difficult to demonstrate voter suppression. And on this one, the petition has failed to demonstrate that there was voter suppression, in my respectful opinion.
All right. And yes.
Well, you know, we heard earlier that Wafula Chebukati, the boss of the IEBC, has said that the commission has now been vindicated. All eyes were on the IEBC and on him as well. Professor, what next for that commission that many have argued is toothless? I mean, we are going into an election 5 years from now. What needs to happen to ensure that we don't see any of these issues and discrepancies in future
yeah,
elections?
fine. But before I come to that, I think that the co-debater, I think he didn't hear the evidence that I was giving. I didn't just give theory. I gave contagion theory and I gave evidence of issues. Please, let me go to the next, please. I think listening helps. So the next issue is this, that the chairman, Chebukati, again, three-pronged. Number one is the issue of what was stated in the petition, what was responded to, and I always cite. It's always good to cite. If we read, we cite. If we don't cite, we only cite one paragraph. That's not sufficient. So the petition, or the petitions, and this time please note that there were, is it initially 9? Reduced. One was dismissed earlier on, Moses Kuria, and then
7 were consolidated.
Consolidated, and then the petitions, the affidavits, the submissions, and indicated that there are problems, including, of course, from fellow commissioners. That's number one. Number two, the judges' questions indicated that there was a problem. In fact, the judges sought to distance themselves from the mention of IEBC like a plague. Oh, don't compare to IEBC. And that shows that there was some kind of judicial notice, what lawyers in evidence call judicial notice, that we are aware. We are in this country, we know. And they talked about quite a lot. Most of the judges also talked about the dysfunctional domestic chores, that's CJ's language, etc.
Right.
So, judicial notice is part of evidence over dysfunctional IEBC. Judicial notice is part of, is actually the Evidence Act. Yeah, because sometimes you don't need to prove everything if it's something that is clear and is obvious. Lawyers sometimes also call it res ipsa loquitur. The thing speaks for itself. But
at the height of this kind of case at the apex court, you surely have to substantiate what you bring forth as a petition with evidence.
Yes, you have a burden. There's no doubt about it. He who alleges should prove. Then, of course, you prove with evidence. And evidence, but hey, evidence is oral evidence, or testimonial, there is documentary, there is a thing itself, but there is judicial notice, or there is opinion evidence, etc. Okay. Those are part of evidence. And so when I hear that the court said there is no evidence, so there is no evidence, I think scholars have a duty, and lawyers, to analyze, to go beyond the judgment. You don't just say, the court said, the court found, and therefore so it is.
Prof, we've got to wind up soon. So briefly, what in your view is the next step for the IEBC?
It's been dysfunctional. Chebukati was indicted, and the commission was indicted in the 2017 decision, which was very clear that and in fact the court was even choosing the language that probably sanctions ought to be applied here. I think that it's going to be a tough, the dynamics there are going to be tough. Of course, we recognize that they have security of tenure.
Right.
They have security of tenure, but in terms of the dynamics of working relationships, where the court also took judicial notice that they have an imperial chairperson, and they were comparing themselves to the court, they saying that we are a team for you, you see, this, we are not. I think there is going to be quite, I don't want to speculate, but the dynamics would have to be worked out, because the commission is an important player in in our realizing our sovereignty.
Professor Sihanya says Chebukati was indicted by the previous judgment in 2017, but he feels he's vindicated with the Supreme Judgment today. As she asks, and I'm sure Chebukati thanks God he will probably not be presiding over another election, general election in Kenya. What is the future for you in terms of the IEBC, the body?
I think we go with what the court said. The details of it, of course, will be in the detailed judgment, but it notes that there is serious malaise in the governance of the IEBC.
Yes.
So at two levels, generally in terms of how it functions as a commission, we expect that we should anticipate that there will be recommendations to that effect. But number two, the court will give an interpretation to Article 138, particularly Sub-Article 3C and Sub-Article 10, which in my view seem to have not been drafted very well, hence the confusion. But as you can see, the court is already saying that the power to verify the results vests in the body, the commission, acting through its staff under the supervision, oversight of the chair and the other members of the commission. The chair declares results as a delegate of the commission, and you anticipate that there will be some regulations that will give effect to these.
Okay.
What I'm not sure about is the power of recommendations. If in 2017, both the Supreme Court and Maina Kiai had pointed to clear problems and even recommended some.
Perhaps there will be some clarity from the opaqueness of what you're not sure about in 21 days. They say they're going to give us the longer judgment with some recommendations. So unfortunately, our time here is done for this conversation. But Professor Sihanya, Professor Kech, thank you so much for lending your interpretation of what happened today. And I believe you promised last week that you'll be on with all due respect, so probably you'll be back in a few hours. Even Sihanya, I'm sure he would be willing to contribute to these conversations moving forward after this Supreme judgment. But in now making way for the 13th of September, that is assumption of office of the President-elect William Ruto, something else has to happen, and that is activity